Pull up your 401k beneficiary form. The name on it is who gets your money. Not the person in your will, not the person you told over dinner. The name on that form. In 2001, the Supreme Court decided Egelhoff versus Egelhoff. David Egelhoff divorced in April 1994, never updated the form, and died in June. His ex-wife received the retirement plan and life insurance payout. His children got nothing. Washington State had a law designed to prevent exactly this. The Supreme Court ruled, that law does not apply to federal plans. The Form 1. That is the principle governing every 401k and most IRAs in the United States. This video covers the mechanism itself, why the form outranks your will, what happens at divorce, and the 4 moments when you must update it immediately. Your will does not see your 401k. This is not a gap in the law and not a rare legal nuance. It is the standard architecture of the American system of wealth transfer. When a person dies, most of their assets enter the probate estate, the pool of assets a probate court distributes according to the will. A house, a car, a bank account without a named beneficiary, cash, all of these are probate assets. The court opens proceedings, creditors file claims, and only after the debts are satisfied do the heirs receive what is left. This process takes months to years. Retirement accounts work differently. A 401k, IRA, 403b, employer retirement plan, none of them enter the probate estate. When the owner dies, the plan administrator does one thing, opens the beneficiary designation form and transfers the money to the person named on it. The probate court never sees it. The will never reaches it. No judicial oversight. Only the form. The same applies to life insurance policies, annuities, and brokerage accounts with a transfer on death designation. These instruments are called non-probate assets. Americans hold more than $30 trillion in retirement plans today. Most of that money moves not by will, but by beneficiary form. And that means the question of who gets your money is answered not by the document you drafted with an attorney, but by the form you filled out on your first day of work. A beneficiary designation form is not a formality at account opening. It is a contract with your retirement plan, one your will has no legal right to override. When you open a 401k through your employer's online portal or the HR department, you are asked to fill out a beneficiary designation form. Most people do it in 3 minutes. Once the form is signed and registered, it is held by the plan administrator. When you die, the administrator has one obligation: locate the active form and transfer the funds to the person named on it. This is not discretion. It is a legal duty embedded in the plan documents themselves. Most retirement plan documentation states this directly. The typical language reads, "The plan administrator recognizes only those beneficiaries designated by the participant in a properly executed form. Designating or changing a beneficiary through any other document, court orders, prenuptial agreements, wills, or trusts, is not permitted." That is not fine print. That is the central operating principle of the plan. The result is straightforward. Your 401k passes to the named beneficiary before a court ever opens proceedings on your will. Heirs named in the will may receive everything else, except the assets that have their own form. But here is where the mechanism becomes harder. Behind this rule is not just your plan's documentation. Behind it is federal law. Most Americans have heard the acronym ERISA, but do not know what it gives them or what it takes away. ERISA is the Employee Retirement Income Security Act, enacted in 1974. Its central purpose is to establish uniform federal rules for employer retirement plans. To accomplish this, The law includes Section 514. It explicitly states that ERISA supersedes any and all state laws insofar as they may now or hereafter relate to any employee benefit plan. This is called preemption. In practice, if your 401k is governed by ERISA, a state law attempting to influence who receives money under that plan does not apply. This has direct consequences for your beneficiary designation form. Many states have passed laws that automatically revoke a spouse's beneficiary designation upon divorce. The logic is sound. If you divorced, your ex-spouse automatically loses rights under your documents. Most people believe this law protects their 401k. It does not. The IRS states directly, a plan administrator may rely only on the plan's terms and the beneficiary designation documents. A divorce decree is not such a document. This is why ERISA turns the form from an administrative piece of paper into the only thing that matters. And this is not a theoretical rule. In 2001, the United States Supreme Court heard exactly this kind of case, and its decision became the precedent for every retirement plan in the country. In 2001, the United States Supreme Court ruled that an ex-wife was entitled to her husband's retirement savings because the form named her. David Egelhoff worked at Boeing in Washington State. Through his employer, he had two documents, a life insurance policy and a retirement plan, both governed by ERISA. Both named his wife, Donna Ray Egelhoff, as beneficiary. In April 1994, they divorced. On June 18, 1994, David was killed in a car accident. Neither document had been changed. His ex-wife received the payouts under both. David's children from his first marriage filed suit. They relied on Washington state law, which automatically revoked a spouse's beneficiary designation upon divorce. The lower courts sided with the children. The Supreme Court did not. In Egelhoff versus Egelhoff, 532 U.S. 141, the court held, Washington's law was preempted by ERISA. A plan administrator is required to follow the plan documents and the beneficiary designation form, and nothing else. The state's automatic revocation law had an impermissible connection with ERISA plans because it substituted a state law beneficiary for the one named in the plan documents. This violated the principle of uniform federal administration. The ex-wife received the money. The form won. Every time. If you want to understand whether your state's protections apply to accounts outside ERISA, subscribe. The next video covers exactly the layer most people miss. A divorce decree does not change your beneficiary designation form in an ERISA plan. This is one of the most common and most expensive mistakes in American estate planning. When a court issues a divorce decree, it divides property, establishes alimony, sets rights to jointly held assets. Family court operates on probate assets and contractual relationships. It has no jurisdiction over your 401k because that is a federal plan. A divorce decree is a state court document. For an ERISA plan, it is not a beneficiary designation form. What you must do immediately after divorce: go directly to the plan administrator or your employer's HR department and submit a new beneficiary designation form. Not send a letter to your financial advisor. Not include an amendment in the divorce settlement. Submit a new form directly to the plan administrator. Courts sometimes issue an additional document, a QDRO, Qualified Domestic Relations Order, specifically designed to divide ERISA assets in a divorce. But a QDRO addresses a specific distribution as part of the dissolution of the marriage. It does not rewrite the form for the future. If after the QDRO is executed, you do not have a new active beneficiary designation form, the next beneficiary is whoever you named a long time ago. If your ex-spouse dies before you submit the new form, their name is still on it. The plan administrator pays their estate. But divorce is not the only moment when marital status affects the form. While you are married, a different mechanism operates. If you are married and want to name someone other than your current spouse as the primary beneficiary of your 401k, filling out the form on your own is not enough. You need written spousal consent. ERISA Section 205 establishes this directly
for qualified retirement plans with a right to a spousal annuity, and most 401k plans qualify. The current spouse is the default beneficiary. To name someone else, the spouse must sign written spousal consent in the presence of a notary or a plan representative. This works in both directions, and the result often surprises people entering a second marriage. A new marriage does not automatically make the new spouse the beneficiary if the prior form names someone else.
A child from a first marriage who was listed as beneficiary before the new marriage remains in that role until the new spouse signs notarized spousal consent to change the form. The reverse is also true. If someone remarries but does not update the form, the new spouse has default rights to the spousal annuity, but not necessarily to the entire account if the form names someone else. Think about what that means for your account. Your marital status affects the plan through the form and through spousal consent. A will is not the instrument here, but the form itself is only the first layer. When the beneficiary receives the money, a mechanism awaits them that most people do not know about in advance. When your 401k or IRA passes to a beneficiary, the heir cannot hold the money in the account indefinitely. Federal law starts a specific clock.
Before 2020, most beneficiaries used what was called the stretch IRA. An inherited account could be drawn out over the beneficiary's lifetime, taking required minimum distributions each year while allowing the remainder to grow tax-deferred. The Secure Act, signed in 2019, eliminated this option for most categories. The rule now is this: if the beneficiary is not a spouse, a disabled individual, a chronically ill individual, a minor child of the account owner, or a person not more than 10 years younger than the owner, they are required to withdraw the entire balance within 10 years of the owner's death. According to IRS Publication 590-B, amounts not withdrawn by December 31st of the year 10 years after the year of death are subject to excise tax. For the beneficiary, this means concrete pressure. Every withdrawal is taxed as ordinary income. Inheriting a retirement account with $400,000 at age 50 is not the same as receiving the same money in retirement. Tax rates, the timing of withdrawals, your other income in the same year, all of this determines how much you actually keep. You name a beneficiary now. The rules under which they receive the money are the rules in effect now, and the rules change. But the simplest way to manage this mechanism is to make sure the form names the right person in the first place. That comes down to 4 specific moments in your life. A beneficiary designation form does not update itself. Only you update it. And there are 4 moments when you must do it immediately. First, divorce. A divorce decree does not change the form on an ERISA plan. The moment the dissolution of marriage takes effect, file a new beneficiary designation form with every retirement plan, every life insurance policy, every IRA. Second, new marriage. A new spouse does not appear on the form automatically. To name them as primary beneficiary, you need a new form. To name someone else, you will need their notarized spousal consent. Otherwise, ERISA Section 205 defaults the spouse into the beneficiary position. Third, birth of a child. A child born after your last form does not appear on it. If they are not named on the form, they receive nothing from the retirement plan, regardless of what the will says. Fourth, death of a beneficiary. If the primary beneficiary predeceases you and the form has not been updated, the money goes to the contingent beneficiary, if one is named. If there is no contingent, the funds fall into the probate estate. A retirement account that spent its entire existence bypassing probate court ends up in it. One additional case: changing employers. When a 401k is rolled over into a new retirement plan, or IRA, the old form does not transfer. The new account requires a new beneficiary designation form. The form lives on your plan's portal. Here is what it controls. Who gets the money? The will does not answer for it. Here is the full picture. Your 401k, your IRA, your life insurance policy, these are not parts of your estate plan in the way a will is. They are parallel legal instruments under federal law. Each one has a form, and the form controls everything. The probate court never sees them. The will does not rewrite them. At divorce, the state's automatic revocation law does not reach them. The Supreme Court confirmed this. The form won. Every time. Benjamin Franklin did not just say a penny saved is a penny earned. He built systems. He wrote contracts, not intentions. The man whose face is on the $100 bill understood. A signed document is worth more than a stated wish. If you want your money to reach the right person, sign the right form. A will is a wish. A form is a mechanism. The wish loses. If you want to understand the next mechanism, what actually happens to your money on its way to your heirs from a tax perspective, subscribe. That is the next video.